Are you guys on right now, you guys? Or I don't know if you can even hear me. Yeah. Yeah, I guess the hearing is, that if they approve it, I guess tomorrow's when there would be hearings on the DNA. So this hearing apparently is regarding whether or not they're going to have public hearings tomorrow. All right, so there you go. Maybe I could try this one.
All right.
There we go.
We are on the record in State versus Brian Kohberger, CR 0124 31665. The state is represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. The defense is represented by Ms. Taylor and Ms. Massoth. The defendant has been excused from appearing. The defendant himself has been excused from appearing today. With us also are petitioners, counsel representing petitioners, Ms. Olson and Mr. Pedersen. Today's hearing was set to address the interested parties' petition to be heard as interested parties related to the court's closure of a portion of the hearing set for Thursday and Friday. So with that, I will let, whether it's, I'm not sure if Ms. Olson or Mr. Peterson is addressing the court today, but whomever is may address the court.
Thank you, Your Honor. Will be Ms. Olson on behalf of the interested parties who are various media organizations and professional journalist organizations with a history of covering the proceedings in this case. And the interested parties thank the court for this opportunity to address this issue regarding press and public access to the hearings that are scheduled to start tomorrow at 9 a.m. Your Honor, as the court knows, the United States Supreme Court has long acknowledged that the First Amendment protects the rights of the public and the press to attend criminal proceedings. And while few cases in Idaho have dealt directly with public access to pretrial proceedings, and in particular suppression hearings, at the federal level, both the United States Supreme Court in Waller versus Georgia and the Ninth Circuit in Associated Press versus U.S. District Court for the Central District of California and in United States versus Brooklier have addressed the issue. Waller did so in the Sixth Amendment context. Brooklier found that the First Amendment right of access extends to suppression hearings, and in Associated Press, the Ninth Circuit extended the logic in Brooklier to pretrial filings, writing in the very first part of its opinion, there is no reason to distinguish between pretrial proceedings and the documents filed in regard to them. Notably, both Associated Press and Brooklier involved high publicity, highly public defendants and charges. Associated Press involved federal narcotics charges against, among others, John DeLorean, and the Brooklier case involved a RICO prosecution against members of the criminal enterprise La Cosa Nostra. Waller, in particular, in its decision, sets out the benefits that the U.S. Supreme Court has seen in its various decisions that arise from public proceedings in criminal cases. It notes that in Gannett, a case in which the United States Supreme Court looked at but did not decide the issue of press access to suppression hearings, that the requirement of a public trial is for the benefit of the accused, that the public may see he is fairly dealt with and not unjustly condemned, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility and the importance of their functions. And in turn quoted other cases. In addition to ensuring that the judge and the prosecutor carry out their duties responsibly, a public trial and public proceedings encourage witnesses to come forward and discourages perjury. Your Honor, prior to closing a criminal proceeding, a court must afford those excluded from the proceeding a reasonable opportunity to state their objections. We appreciate the court providing us that opportunity here. And the court must also comply with the requirements set out in Press Enterprise 2 before it can close those proceedings. A criminal proceeding can only be closed if the court makes specific findings on the record as required by that case. And those specific findings need to be sufficient in writing, insufficient so that a party excluded can challenge them. The Ninth Circuit has explained that a court cannot be closed in criminal proceedings unless such closure serves a public interest. There is a substantial probability that in the absence of closure, this compelling interest would be harmed, and that there are no alternatives to closure that would adequately protect the compelling interest. And that's in Oregonian at 920 F. 2nd at 1466, quoting from the Press Enterprise 2 test. Here, Your Honor, the interest parties are not arguing for a blanket order opening the court. We are arguing for the court to adhere to this long-established process of determining how and under what circumstances a court could be closed for a hearing. For many of the media outlets we represent, even in national security, child sex assault, and organized crime cases that they cover, the process that we are seeking has been carefully followed. The public and the media have a right to appeal unwarranted closures of a courtroom, but they're unable to determine whether the court is being closed appropriately because the court so far has not made public the most basic information regarding the reasons for its closure. The defendant in this case, in both its January 13th and January 21st filings, seeks an open hearing and asserts that an open hearing is of most importance to him. Therefore, any concerns about the closure being required to ensure the defendant's right to a fair trial are moot. And as Mr. Kohberger pointed out in his motion to hold an open hearing, the Supreme Court in Waller held that when the defendant objects to the closure of a suppression hearing, the hearing must be open unless the party seeking to close the hearing advances an overriding interest that is likely to be prejudiced. The burden is on the party seeking closure. That's from Oregonian 920 F. 2nd at 1467 and 685 F. 2nd at 1167. As we understand it, Your Honor, the interest being advanced by the state is concern for information being provided to the potential jury pool and possible inadmissible evidence being discussed in open court. But that is inherent, Your Honor, in any motion to suppress hearing. The whole basis of the hearing is to see whether the evidence should be excluded or admitted at trial. Concern about the public maybe learning about this evidence, and even if it ends up being inadmissible, is therefore not an overriding interest. And absent that some evidence that this discussion that would occur in the hearing would taint a jury pool or provide information that would be difficult to seat a jury, I think that is also not sufficient evidence for this court to find that it's a compelling interest and warrant closure of the hearing over both Mr. Kohberger's objection and then the right of public access. It also appears from Mr. Kohberger's filing yesterday that the state asserted that Mr. Kohberger's acquiescence to the non-dissemination order is somehow a basis for them to argue that Mr. Kohberger cannot now object to this closure. Not certain if that was the argument that the state advanced, because we haven't seen their pleading. It's not on the cases of interest website. But as I understand the non-dissemination order, Your Honor, and its purpose, it's directed at comments or statements that are made outside of court proceedings and pleadings, and not at what can be said by the parties or their counsel in the courtroom. And the very purpose of the non-dissemination order, as I understand it, Your Honor, was to prohibit those sorts of extrajudicial comments by people who would be in the know, but that in-court proceedings are precisely the kind of information that should be available to the public as this case moves forward. Your Honor, I would submit also that there is tremendous public interest, and it serves a tremendous public good for the public to know at the time that it's being considered the evidence, whether the evidence that the state seeks to introduce at trial was gathered in a method that is constitutional or meets evidentiary thresholds for admission. A motion to suppress may be the critical stage of a criminal case. If essential evidence is suppressed, then the government will not be able to meet its burden of proof at trial. Indeed, Mr. Kohberger made that exact argument in his filing yesterday. The purpose of the IGG was to investigate a criminal case. What is more, without IGG, this case would never have been brought against Mr. Kohberger. The public should know precisely what law enforcement and prosecutors did in gathering such evidence and why and how the defendant thinks that was illegal. The court in Waller, when it was talking about the aims and interests of a public trial, noted that those aims and interests are no less pressing in a hearing to suppress evidence. And then they pointed again to several of the individual opinions in Gannett, the case where many Supreme Court justices opined that if they were addressing the question, they would say there's a First Amendment right of access to suppression hearings, but they didn't reach that question. In Gannett, the comments that many of those justices made was that in many cases, the suppression hearing was the only trial because the defendants thereafter pleaded guilty or the evidence was suppressed and no case went forward. And similar reasoning supported press access to preliminary hearings in one of the few Idaho cases to address access to pretrial hearings, and that was the Cowles case. In Cowles, the Idaho Supreme Court noted that the process in conducting preliminary hearings in Idaho is likewise sufficiently like a trial to generally justify public access. And they pointed to the Supreme Court opinion in Press Enterprise 2, where they state that because of its extensive scope, the preliminary hearing is often the final and most important step in the criminal proceeding. The preliminary hearing in many cases provides the sole occasion for the public observation of the criminal justice system. And that may be the case in a motion to suppress hearing, particularly if either that motion is granted and not sufficient evidence exists to go forward, or even it is denied and a plea deal follows the resolution of the motion to suppress. In a Franks hearing, Your Honor, the court is addressing the very critical issue of whether a law enforcement officer made deliberate or reckless false statements in an affidavit submitted to the court. And prior to holding such a hearing, a court is to determine that whether the defendant has made a sufficient threshold showing that an actual hearing is necessary. An actual Franks hearing, in my experience, Your Honor, is unusual. On issues as critical as these, whether evidence was gathered properly and whether law enforcement made deliberate or reckless false statements to a court in gathering evidence, there is significant public interest, and public access plays a significant positive role in the functioning of the particular process as the court outlined in the earlier cases I've identified. It's particularly true here, I think, Your Honor, with the Franks hearing, where there is that question regarding the truthfulness of the officer involved. In any criminal case, I would submit that it's of extreme public interest to know whether a law enforcement officer swearing that they have told the truth in a filing with a judge that will be used to gather evidence that can significantly impact the life and liberty of an accused, whether that law enforcement officer did in fact tell the truth or whether the officer made deliberate or reckless false statements. I think it would be different, Your Honor, if it were a private citizen who made a misstatement of facts and there was a hearing about perhaps that person. The calculus might be a little bit different, but this is a person, a law enforcement officer who is cloaked with authority and has the ability to seek process, to get evidence, and ultimately lead to charges against an individual. Your Honor, the last thing that the court has to look at with respect to whether or not to close a hearing is whether there are alternatives to closure. And Your Honor, it is a little difficult in this situation for the interested parties to specify what that alternative to closure might be. But sort of looking at the documents that have been filed in this case and understanding that one of the initial concerns with the IGG evidence is the identity of perhaps family members of Mr. Kohberger, I would submit that there are two alternatives at least that might address that. One is that it's possible, of course, to show exhibits on a monitor in a hearing in court in a way that they're not displayed to people who might be watching online or in the courtroom, similar to what is done when there is a piece of evidence or an exhibit that is offered, but it's not yet admitted. I would also submit, Your Honor, that perhaps redactions or some sort of general identifier, person one or person two, in the place of a particular name would be sufficient if indeed the concern is revealing the names of relatives of Mr. Kohberger. That's very similar to a process that is done in healthcare fraud cases when we're dealing with individual patients whose records may be at issue in a case. and not a medical malpractice case, but a healthcare fraud case where we're looking at the billings, and those individuals are often identified, for example, by a random number or by a Medicaid identifier number, and not by their name. So their names are never revealed in the course of the proceedings. And so, Your Honor, we would submit that alternatives to closure such as that would be available to the court if the concern is identifying those particular names of people who are extended relatives of Mr. Kohberger. Finally, Your Honor, openness and transparency are more important than ever in maintaining and restoring public confidence in our government institutions, in our courts, in law enforcement, in prosecutors' offices, and in institutions of the media. Open hearings, like an open suppression hearing, are necessary to let the public see how this critical part of our criminal justice process works. Thank you, Your Honor.
Thank you. Does either the state or the defense wish to add anything based on Ms. Olson's argument that was not previously presented?
I would like to make a record on behalf of the defense.
Beyond what you did yesterday?
It would be consistent with what I did yesterday.
Okay, but I heard what you did yesterday. So do you have anything new to add?
Oh man, they picked the wrong judge here. Holy
I
crap.
don't have new information to add, Judge, other than having the ability to talk with the team about what your suggestion was and our concerns about arguing in open court. Would you like me to just address that?
I'm not sure what you're referring to, so I apologize.
So we had discussed that the evidentiary hearing portion of it for the IGG would be closed.
Correct.
But that we would argue the legal arguments in open court if we did not talk about the evidence that was brought out in the closed hearing. And after thinking about it overnight and talking about it today, we do not think that we can parse the argument that way. So it's still our position that all of this should be held publicly, openly in court. And that's our same position with the Franks. The Franks proffer, with the exception that there will be, in the proffer, there will be a need to talk about specific names and in particular names of some lay witnesses in directing the court to the 1,000 pages that were submitted under seal in relation to the proffer.
All right. Well, with
So
respect to the names, I'm sorry. With respect to the concern with respect to using names, submit a list of names with initials tomorrow, and you can use the
I
initials.
almost started playing the clown music. It's the
we
stupidest
can do
argument in
that.
the world.
Anything from the state, Mr. Thompson?
Not for me, Your Honor. Mr. Nye was actually speaking on behalf of the state yesterday. I'll defer to him.
Mr. Nye?
No, Your Honor, nothing beyond what was said yesterday. Thank you.
All right. Well, I appreciate the presentation today. I will note this case is a little bit of an unusual posture in that there was previously a non-dissemination order issued in this case in which it was clear the tract of the court and at the time the parties was to avoid given the media scrutiny, the potential for impacting the jury pool that exists here with evidence that may ultimately not exist and evidence that may not ultimately be admissible. That order was challenged, I believe, by the press at the time, and the full hearing was held on that, and the judge issued an order on that. The closure of the proceedings thus far have been consistent with that prior ruling by the court, for which the petitioning parties were given an opportunity to be heard previously. I don't think much has changed in terms of the need to protect the jury pool here, given the intense media scrutiny that has and continues to follow with this case. Part of the rationale presented to the court yesterday for opening it was in order for the defense to make their case to the public. It's exactly why it's not open. We will be challenged under the best of circumstances of obtaining a jury that is not been overly exposed to this, and in particular exposed to evidence that ultimately may not come into this trial. I am, as I told the parties yesterday, particularly sensitive about closing things when we don't need to, and I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and to provide better rationales as to why I should seal what they're asking me to seal. That said, with respect to in particular, the IGG issues, particularly where I don't exactly know what the evidence will be forthcoming, I am concerned about the potential impact on a jury pool. In this case was moved to this court because of the defense's assertion that they could not get a jury pool in northern Idaho that would be unaffected by the case, even with the non-dissemination order in place. The media here in Ada County is as, if not more, intense. And so I think there is need to be careful when we are addressing evidence that potentially is not going to be evidence in the case because of suppression motions in limine and the like, which is the concern that I have in particular with the Frank's hearing, as that does appear to be evidence may not come in, and it may not be evidence that has been particularly disseminated to date. As I talked with the party, there are other issues that I've asked the parties not to address specifically as it relates to some of the motions to suppress that doesn't need to be discussed specifically. For example, the evidence produced by the warrants they seek to strike. And is that for that reason, my intent has been and continues to be that we will have as much of this hearing open by way of streaming possible.
Okay.
I have not
All right.
and will not open the courtroom itself to parties in the courtroom because of the need to close it if I find or the parties suggest to me, and I agree there's a need to discuss something at that moment outside the public's reach. Which is easy to do by simply going offline for a minute. And that's what I intend to do tomorrow. In particular, the evidence with respect to the IGG, I think at this point it's appropriate to, and I will issue an order shortly, to keep that out of the public domain for the time being. Now, that may change down the line. My order certainly on the issue will ultimately give some information so that people can follow what happened from a legal perspective. But some of the factual details, until I know what those are, and I've seen that, I can't make that determination better. And so I think that this is the best way to proceed because I can't unring a bell once it is rung with respect to potential evidence that in particular may not be evidence in this case. And so my intent would be to proceed with the evidence portion of the Frank's hearing as it relates to IGG in a closed environment. I think we can decide at that time, before we go online, whether we can have the IGG portion of the Frank's proffer publicly.
Yeah.
The intent is, I think we understood from discussion yesterday that the rest of the evidence and the arguments, both on Frank's and suppression as it relates to everything else, we should be able to do public. If there's an issue that is specific, like Ms. Massoth brought up, about the need to mention a name that we need to protect from unwarranted harassment, which has been a concern in this case, we can certainly refer to them by initial, particularly if you give me a roster with initials or other identifiers you'll be using, then I can follow along. And I think that's the better way to proceed, so that we can do as much of this in open light as possible.
Okay, there we go.
So I appreciate the petition. I don't think it has changed. I appreciate the defense has shifted its position to a degree here. I'm concerned that the purpose of the shift is to try the case publicly, as was offered to me. That doesn't give me comfort, to be frank. But for the meantime, until we can, I can get a handle on the exact evidence that does in fact come in, given that it is potentially evidence that will not be admissible, and anyone who hears about it may therefore be removed from the jury panel.
In any case,
I think it's better that we proceed in this fashion for now.
May I raise one other issue, Your Honor?
Briefly.
Thank you, Your Honor. So first, Your Honor, with respect to the non-dissemination order, respectfully, we represented the interested parties at that time as well. In our understanding of those proceedings, it was amended a couple of times. The second time after we moved to intervene and challenge the dissemination order then in place. And as I understood Judge's the proceedings in front of him and the non-dissemination order, the purpose of that was to preclude extrajudicial statements and was not to preclude the attorneys from saying things in court that would be made public. The goal was to make sure that there was accurate information from people knowledgeable about the proceedings, and that was the forum in which they could do it. And I would also note that Rule 3.6 does have sort of this rebuttal portion to it that allows, if the defense, if there is a statement that is made, under Rule 3.6, the defense is permitted to make public statements to sort of counter that. And I think that's probably what the defense was getting at in its submission to the court. And then finally, Your Honor, are the court's statements in court today intended to be its specific findings regarding the manner in which the court is to implement the Press Enterprise 2 test, or will there be a written order so that my clients can be adequately prepared to decide what next steps to take?
Yeah, as I indicated, I intend
It
to
is the
issue a
same,
written
Judge.
order
What do you mean it seems
following
to be?
today's hearing.
Okay.
I don't think that what you said accurately reflects my understanding.
They got rid of
the defense's position yesterday, but I appreciate that.
Change venues.
I do understand Judge's prior order to be dealing with extrajudicial statements, because that's who he could control at the time, were witnesses and parties. But I also understand from a review of the record, there has been a concern throughout this case of exposure to evidence that may ultimately be inadmissible, and that prior proceedings were closed for that purpose, consistent with Judge's ruling at that time. I agree it would be an extension of that, but in general, I think that's where they've been throughout this case. So, and at the end of the day, regardless of the outcome, the likelihood is everything will be unsealed. And before then, as soon as it can be done in a way that protects the case and the jury pool, which is the parties' rights, both parties' rights to a fair trial is paramount, as is the public's right to know. But I also have to weigh that against the ability to have a fair trial by getting a jury panel that has not been tainted by the publication of widespread publication of evidence that may not be admissible at trial. So it's a bit of a narrow path for the court to have to tread, and I appreciate that, and I appreciate that that calculus isn't always in the direction that one would hope, but I am doing my best to make that calculus in a way to ensure the rights of the parties and to ensure a fair trial, and that we can do that as quickly as possible. All right. So I will issue an order forthwith, and tomorrow we will come forward with public hearings just as soon as we can. Further, if after hearing that evidence I determine it doesn't need to be protected, I will order a transcript be prepared, and I will order that be produced. But in the meantime, I think I need to take this course, so I appreciate that. Thank you.
Thank you, Your Honor.
Well, this judge is a hell of a lot better than Judge, I can tell you that. I think that these guys probably are, I'm not sure, I got so much crap on my screen from other stuff that I was working on, but, they have so much, I don't even know what the hell I was saying. But anyways, tomorrow, it sounds like they're going to have, part of the hearings will be, just like their order said, that tomorrow part of their hearings will be public. Hey, thanks, Kami. So, no, Super Goat Gazer, that's not true. Okay. So anyways, the way this worked in this case is the FBI deployed a rapid forensic, or IgG, on the DNA that they found underneath the knife, the clasp of the knife sheath. And then they used some techniques that are sort of backdoor methods that were able to get more information than they should have by using family tree DNA, because places like GEDmatch and the normal use of family tree DNA don't have enough. Sometimes they don't have enough to get you quickly to where you need to be, because they were on the hunt for a killer here. So they had the DNA, and then they were able to it's investigative genetic genealogy, IgG, and it's also known as FGG, forensic genetic genealogy. And so they got, if you guys want to know what the deal is, I can tell you right here if you just pay attention for a couple minutes. All right, we've gone over this 1,000 times. The DNA that was found underneath the button of the knife sheath, they were able to do IgG on it using family tree DNA, sort of a backdoor sort of known glitch where they were able to access and use more names than normal on it. Okay, so they were able to determine that it was like, I don't know if it turned out where it led right to Brian Kohberger or Kohberger's family. So what they did was, it was Kohberger's family, and they found out that he had a white Elantra, and he lived there on campus. They followed him home, and then they surreptitiously gathered some garbage out of the garbage can, and they were able to determine that the DNA on the garbage can was the biological father of the killer. Now, all Kohberger has is a sister, and she wasn't there, so it leads to Brian Kohberger, and that was enough to swab Brian Kohberger's mouth and get a sample and compare it to the original sample found on the knife sheath, and it matched 100. I mean, like, there is no other option. It was in the, octillion, 3 octillion or something to 1 that it wasn't his. I mean, it was ludicrous. So the DNA is his. Now, the defense is trying to bitch and moan and complain that the tip was generated in a way that is, wasn't quite right. We don't really, we don't like the way it's generated. The truth is the tip came in, and then law enforcement has to go out and try to, look at it. They go out and they try to prove the tip is true. So they go out and do the due diligence. Okay, wow, he had a white Elantra. He came from here. He's over there. They start looking where his phone pings and etc. And now it looks like they're onto the right guy. They sent out somebody to collect DNA. It turns out it's the biological father in the garbage can. And we know the only reason they couldn't find Brian Kohberger's DNA in the garbage can is because he was sitting around in his kitchen at night wearing gloves and removing his own trash and putting it into plastic bags and then putting those bags into the neighbor's garbage cans. But I mean, that doesn't imply guilt at all or anything. I think he was doing that because he was paranoid that he was pulled over twice on the drive back. And so that's it. What difference does it make how a tip is generated? It doesn't matter at all. These guys are, if the judge rules in the defense favor, he's an idiot, okay? He's just as dumb as a lot of people out there. I'm just telling you. It is absolutely ludicrous. So if you had a psychic out there and they said, hey, I think had a hot gilligan little bunny skip up. Okay. So let's say you had one of these guys doing one of those, EVP or the, what's that called? Spirit box reading. And they told the cops, hey, man, I think this guy is the killer. And they go, oh, come on. And oh, trust me. And the cops go over, they look into him, and my God, they investigated, and it turns out he is the person. Now, do they have to bring the guy in court and say, well, how did you do this? And he goes, well, I talked to spirits and everything. What difference does it make? The tip turned out to be true, and it worked. It was right. So, yeah, they probably, or technically, like behind the scenes, using the software, it's not illegal. It's just against the terms of service. They were able to go in there and get a lead. And it led to Brian Kohberger. Okay? Now, some other thing in there didn't really lead to Brian Kohberger, and they were making pieces fit because they wanted it to, then there might be a problem there. But that's not generally how it works at all. They just did some techniques where they were able to quickly do genetic genealogy, something that sometimes, without enough information, takes months and months to get a lead. They needed it quick, so they took this shortcut using family tree DNA shortcut that they had, where it accesses, I think, the entire database, which is a huge, way bigger than the small amount that was for law enforcement use only. And they got a name, and then it led to Brian Kohberger, and they had to investigate Kohberger. It turns out he was the guy. Everything matched. He answered all the questions that they had. So it was a tip that led to identifying Brian Kohberger. These guys are bitching about how the tip came in. It's childish and stupid, but hey, you got to do what you got to do for your client, and if it works, then it just means the judge is dumb, okay? That's what it would mean. All right. So that's the truth, you guys. I don't know what else to tell you. Anybody have any questions? I mean, we've been doing this a long time on this channel. We have Dr. Colleen Fitzpatrick. We've given over $100,000 to a DNA fund for identifying Jane and John Does, and that's why your guys' support when I do these shows is so important to allow us to continue to keep doing that over the years. Just in general, the way investigative genetic genealogy works is they have an unknown sample of DNA that they find, just like the DNA on the knife sheath. It's unknown. Then using what they have to do is, I don't know if you guys have done this, but if you use a place like Ancestry DNA, you spit into a vial and you send it off. And after it gets there, they process it, and then you have a profile, and then there's a raw data set that you can download, and you can upload that raw data set to places like Family Tree DNA and GEDmatch. And then you can look for your own relatives on a public database. But in a case of an unknown killer, and it's like touch DNA, something like that, you have to convert that DNA string into something usable by GEDmatch, because you're not spitting into something. So there's a company, Bioinformatics, I think it was called, something like that, where they take the DNA sequence and convert it into a raw data file that's similar to what you can download from Family Tree or from Ancestry, etc., 23andMe, and you just take that file and you upload it to GEDmatch, and then when you upload it, it comes back and it tells you who your highest matches are in a number using centimorgans, it's called. So the higher the centimorgans, the closest relative it is. If you have something like 300 or higher, you have a pretty good chance of relatively quickly figuring out the answer. But if it's like 180 to getting down there, then you're struggling a little bit to quickly do something. So you put the DNA in there and you're looking for relatives and you build out a family tree. You use public databases like even newspapers.com. You can look at obituaries. It gives you all the different names of people. Like somebody dies and it says they're survived by the wife so-and-so, the child, this and that and the other thing, and their grandchildren, So you can start filling out databases using that. And other places, you can get names and start filling out a tree. And you're looking for people on both sides of the tree so that you can start narrowing down to the individual. So you don't have the person's name, but you're on GEDmatch. And then finally you narrow it down to a guy named Brian Kohberger. And you let investigators know that, or it might not even be Brian Kohberger, it might be the Kohberger family, specifically, like that unit of family members, but they just weren't sure if it was, which sibling it was. So they sent the detectives go out and they follow him around, they do other investigation, and it looks like, yes, this is the right guy. We had the white Elantra. He was a professor over there. They look into his background. And then they've tracked him driving back to Pennsylvania. Then when he gets back to Pennsylvania, they surveil him for a while. And they watch him throwing garbage into the other garbage can. So that's even more information. And then they collect the garbage and then they do forensic genealogy on some of the trash. And it turns out it was the father of the killer. It's the father of the killer. That was enough to be able to, and they knew it was, Brian Kohberger is the person they were looking at, I believe, or at least the white Elantra. The white Elantra is part of the case, so it probably ruled the sister out immediately. And then they arrested him, swabbed him, compared the swab to the DNA on the knife sheath, and it was a 1-to-1 match, 100%. There is no other option in, trillions and trillions, of Earths. There isn't one, okay? So there you go. That's it. All right, guys. Well, thank you for being here. We've lost a lot of people when I started discussing the DNA. Nobody really gives a shit about the actual factual part of the case. That's what I get really disappointed in the true crime community. When you start really talking about the nitty-gritty, what it really matters, oh, it's not entertaining, and they just bail like you just wouldn't believe. It's disgusting. Have a freaking, give a damn about the case and what this is about here, okay? All right, anyways, I know a lot of the freaks stay here, but like 50 people, oh, okay, forget it. I don't want to know now. It's just garbage. It's just, give a damn, all right? You might have learned something if you'd stayed for 2 seconds. What do you mean? Is that it's a map on the screen? It's Google Earth, man. Hey, all right, it's Google Earth. Good observation. Yeah, it's a map of Google Earth, everybody. Now, this is my Brian Kohberger map situation here. You see that? Right. So there's some people that find it interesting, but it's amazing how many people bail when it's something that actually matters in the case. They don't want to know, especially if they're Brian Kohberger supporters, because they don't want to hear the truth, the reality of this case. Okay, Brian Kohberger is 100% the killer. Okay, there is no doubt about it at all. This is one of those cases. It's just going to be an interesting trial, seeing how everything's put together and pieces put together. But there is no doubt at all that Brian Kohberger is the killer. Now we're going to get the whiners that show up in here and go, gosh, Gray, what about innocent until proven guilty? You bastard. And I'll say, you're right. I agree with that. I believe, though, he's 100% the killer. There is no doubt in my mind at all that Brian Kohberger killed those 4 people. Now, if you're out there and you're excited that you can, if there's a technicality that gets the DNA thrown out that allows a quadruple college student killer to be walking around, then you go ahead and do it. There is no chance in hell Brian Kohberger isn't the guy. He said he was driving around that night. They have a white Elantra doing initial 3 passes and then does a 4th, but on the 4th pass it actually turns around at 500 Queen Road. There's a camera showing it do that. Then the car drives over to King and Queen, does another 3-point turn. Then the vehicle drives back over to, I mean, I could show you right over here. So the vehicle drives back behind 500 Queen Road here, and then does a 3-point turn. This is on the 4th pass. Drives back over here, does a 3-point turn, then comes back around. You see it right on camera. Drive around, a white Elantra, pulls around here, and then inside this little circle I've got here, the white Elantra stops. It doesn't move anymore. And that's about 2:08. And then at 2:20, that white Elantra is leaving the crime scene area at a high rate of speed. So that means inside of that 12 minutes, the person that was driving the white Elantra killed all 4 of those people. And I believe it was actually in a 7 to 8 minute period where he killed them all. And we've done video after video showing absolutely how long 7 minutes is and how long you would have to spend in each room to do that. And it gets almost to the point where you're like, God, it's taken forever. All right, so he killed them all. So the person goes in there and kills him and then drives away at a high rate of speed. And then amazingly, Brian Kohberger's phone turns on right down here. Right now near, I think it was Blaine, Idaho. His phone turns on, okay? But hey, how do we know it's Brian Kohberger, though? I mean, sure, he was driving around, he was driving around. Oh my God, but inside the house, on the bed, inside the very house that the Elantra was parked out front of, they find a knife sheath. And on the button of the knife sheath is DNA that matches Brian Kohberger, the person whose phone pinged just south of Moscow at like just 25 minutes after the murders. And he drives a white Elantra, and it was missing a front license plate as it was driving around in the neighborhood over here, because it drove by, as it came in originally, it drove by right here, this A&W. It drove by like this. I've driven all these routes. I've got it on video and everything. He drove by right here, and there's a camera on this A&W right here that filmed the white Elantra driving by, missing its front license plate. Then a camera up this street right here on Linda Lane filmed it driving by right there at 3:29 and 49 seconds. Then at like 3:32 back here is the first pass. I mean, everything is so perfectly matched. It is Brian Kohberger, you guys. He did it. If you don't want to believe he did it, you can go stick your head in the sand. You're going to be wrong later. Hey, welcome TRPPS's True Talk. All right, but anyways, I got to get going, you guys. So thank you for being here. Appreciate it. Thanks to Tumbleweed, Alley Cake, Sybil Bergeron, Kami, and TRPP's True Talk. All right. Yeah, who knows why people do it? You know, why did Bundy do anything? Why did Richard Allen kill? We don't know the answers a lot of times, but it's usually a sexual motive of some kind in these cases. All right, but if you guys want to help me with the, I don't know if anybody got me a coffee. Let's see, did we get any coffees that came in? And the answer is no, not even one. Whew, wow. All right, you guys. Thanks, everybody. We'll see you later. And as I always say, until next time, let's see, how do I get up there? Let's see. How do I get this thing going? Be safe out there, everybody. Right there. Yeah, I've been doing this true crime thing for quite a while now.
And
I'll be
during
back
this whole
on
time,
tomorrow
I have
when-
not seen one
to
person
try to cover the live hearings.
that is a
We just don't know exactly when that is.
Flag rejector. I'm a certified human lie detector. Gonna get ya on a stretcher if you try and play me like an old projector. Crime sector is my nectar. Professor Grayl's gonna give another lecture. Crime collector, freak connector, and I'm always gonna be a pop protector. Fool deflector, interceptor, and I'm meaner than a specter with a vector on his pector. With all respect, y'all, just remember I've a temple fucking checker. I have no agenda, I'm no pretender, and I'll serve it to you straight without the blender. And in the end, I'm gonna send ya on a mission to reveal the true offender. Yeah, so I'll just get right back to work. All right, everybody, talk to you later.